21. The first is docket number 370776, William Harrison versus Melanie Hollis. Next is docket number 370791, William Harrison versus Melanie Hollis. As of 9 o'clock this morning, both parties are endorsed for oral argument. You may proceed.
Good afternoon. My name is Stefanie Lambert, and I represent the plaintiff appellant, Mr. Harrison, who is present to my left. There are two matters before the court in this appeal that I'd like to address, and I'll begin with the issue of the refund under MCL 168-867 subsection 6. That language, as we've stated and we rely upon in our briefs, does not include the words or terms early voting site or absentee voting board. The judiciary is not the appropriate mechanism to amend a statute, and the court cannot add new words or terms to statutes. And I would rely upon King versus Oakland County Prosecutor 303 Mishap 222, where it states that the holding was the legal terms at the time of ratification and when the are clear and unambiguous, leaving no room for the judiciary to interpret and must apply the terms in the statute. This recount took place in 2023, a full year after the proposal in 22 had passed, leaving an entire year for the Michigan legislature to amend or pass new laws to provide for early voting site to require an additional fee. And I would rely upon similar holdings in County of Wayne versus Haithcock 471 Mish 445, Kane versus Waste Management 472 Mish 236, Hobart versus Detroit 17 Mish 246, and Stice versus Liquor Control 28 Mishap 358. The Michigan election officials correctly stated that elections in Michigan are run at the most lower level of the municipal offices. It's the cities and townships that run and have the constitutional duty and authority to conduct fair and accurate elections in the state of Michigan pursuant to our Constitution and hold the records pursuant to 4165. What the law does not state is that vendors run our elections. In Michigan, 3 vendors can be utilized by clerks, which would be Dominion, Hart, and ES&S, but they are not to run our elections, and nowhere in the Michigan law does it provide for a vendor to run the election. A recount is a check and balance to ensure essentially that the votes were legal votes were properly counted. And legal is the key term. The most important consideration that I don't think any court has considered in Michigan would be attachment E filed in this case, which is the EAC report. And while it has been stated over and over again that any issue with an election is misinformation, this is from the United States Election Assistance Commission. And on page 4, it discloses that the vendor submitted a root cause analysis showing that its source code was erroneous, which resulted in an inaccurate tally of an election. And this is significant because in Michigan, we report and certify our elections based upon electronic results. The only check and balance on a vendor or a machine count would be a hand paper count and an investigation done at the local most level to be a check and balance to make sure that the electronic reporting is accurate. The election process should never be a partisan or political process. And Mr. Harrison wants to make sure every vote in this election counted, regardless of political affiliation. It's not a partisan process. He submitted in his brief, affidavits reflecting, and this is very concerning because none of the precedent prior to this case contained early voting. Affidavits from people that had voted but were not reflecting as having voted. So what is the explanation for that? Only an investigation would reveal that. And that would mean at the lower level, before an election is certified, a full investigation would have to be conducted looking at paper and all records to make sure that it reconciles pursuant to 4165, and they should be maintained. The court found this issue to be moot. It's not moot because the mootness doctrine states that anything that is likely to reoccur is never moot. And as we know, in the 2024 election that just took place, the Secretary of State did a press release that said that there was a malfunction. Well, she used the slang term glitch with the election machines, and that she had to ask the vendor what the explanation for the malfunction would be. So if we have a scenario where malfunctions can happen with vendors, where nowhere in Michigan law does it say that a vendor runs an election, we have to have a check and balance, which would be a recount and an investigation.
Did a recount happen here?
It's Mr. Harrison's position that it did not, because the machines were used to, again, retabulate, which the EAC report in attachment E details why that's problematic. In that situation in Williamston, Tennessee, the clerk.
So there's an EAC report
Correct.
that you've attached that explains that there was issues with the particular machinery used for the initial vote count and the recount. But the report you have indicates an issue on a single machine or multiple machines in Tennessee.
So in Tennessee, it was a municipality where the clerk did a hand count after the machine count because she suspected something was wrong. She was taking notes throughout the day. She was diligently doing her job. Her hand count did not match the machine count. So she assumed that she counted wrong. So she took the same stack of ballots and put it back through the machine, and the machine count matched the second machine count. So she said, oh, I was wrong, but let me hand count again. So she hand counted again. Her hand count matched her hand count. So her hand counts were all matching, which differed from the machine counts that were all matching. So she involved the Secretary of State, which couldn't answer her questions as to how this could possibly happen. The Secretary of State involved the EAC, which is the federal arm of elections, and the EAC couldn't answer how this could happen. Only the vendor, where there's no transparency, was able to disclose and reported that the root cause analysis was erroneous source code. So that is a problem and would be
Do
unconstitutional.
we have anything to say that the machinery used in this election had an erroneous source code problem?
That's where the investigation needed to take place along with the recount, because yes, that would be attachment G, and the affidavits under attachment C that reflected that many voters were saying that they had voted, yet their vote was not reflected as having counted. So only a full investigation where you reconcile every aspect of the election, because machines are not transparent. When we go to the bank and we pull out cash, the teller runs it through a machine, which tallies it, and then they hand count it in front of you to make sure the hand count matches the machine count. That's the check and balance. So all previous cases that have considered machines for a recount or the statute did not consider what has now been disclosed by the EAC, that there can be erroneous source code. And again, this is not political. We don't know whose vote may or may not have been counted. If you're utilizing that process to conduct a recount, it's essentially just potentially counting errors again, because it's not transparent. That's why it's so important to conduct the investigation on the spot. And that's not moot. That could still be done at this point. Everything has been preserved. And then we would be able to see and actually verify. And the lay definition of recount is to add it up again and investigate what actually happened and how there could possibly be so many affidavits where people are saying that I voted and the system is not reflecting that I actually voted, and I want to know what happened with my vote. I have no idea what their political party is, but no court has been able to consider this EAC disclosure, which took place in March of 22, in conjunction with recounts. And that's what Mr. Harrison is asking of this court. With that, I'd be happy to answer more questions or reserve my time for rebuttal.
I'm just looking at the plain language of MCL 168867, and it's not clear to me where it affords you the right to guide the recount in the manner that your client sees fit. So I understand the desire for the investigation. I understand that the evidence produced of fraud. I understand the apolitical nature of the request, but what I'm concerned about, just given our status as an appellate reviewing court, is where in the statute a petitioner is afforded the right to so intensely guide the recount process.
That's a great question, Your Honor. And it would be our Constitution, it would be the United States Constitution that every legal vote must count. And that is where it just didn't take place. He asked for an investigation, called for one, and the ballots were simply just put back through the machine. And there was no investigation with regards to the affidavit. So it's not just, so there was the Barrow case, I think the court referred to, which did not consider the EAC report where it had been disclosed there can be erroneous source code that results in inaccurate
So are
tallies.
the individuals who voted claiming that their constitutional rights were violated in this lawsuit?
Yes,
Okay, and so they're plaintiffs in addition to your client.
my client has filed the matter and he's included, and he has standing. And so if there's dilution at all in an election, which it appears there could be here, because there's a number of individuals that have said that they voted and it's not counting. It's not just his one vote that should be considered. It's the fact that there was no investigation conducted. And so while the Barrow case talks about a machine recount, this is a new consideration for this court with regard to the EAC report that we report in Michigan electronically. And the check and balance on that would be a recount. And recounts are expensive. And Mr. Harrison overpaid for a recount and was essentially forced to when he was submitting for one because he wanted it done. There's a short time window to do that. And it's not moot. If it could resolve an issue as to a systemic problem that we could have, where we have a number of individuals that have said they voted and it's not reflected as that they were counted, their vote was counted. If that could resolve any problems in future elections or in this election, it's not moot. And for those reasons, we ask that it be reversed and affirmed on the refund matter. And I would reserve the remaining time.
Okay. You have time for rebuttal.